acknowledge that adjournments were made with regard to the speaker. However, my submission is that the draft order itself seeks relief against the first respondent, and in particular to invalidate the letter that was written by the first respondent. That letter by the first respondent purporting to act on behalf of the political party is, with respect, the only issue before this honorable court. As per my earlier submissions, my lord, while the role of the speaker and the consequence of his actions may be an interesting subject for debate, it is not the case that the applicants have brought before this court. And interestingly, the first respondent.
So you were doing it for interest sake.
My lord, I do not abandon the submission that once the speaker has taken up a constitutional role, he is bound by the constitutional principles and is ought to act as an administrative authority that applies his mind. However, as I said in my earlier submissions, once that letter to the third respondent had been written by the speaker, that aspect of this matter is neither here nor there. And the heart of the matter.
We want to respond to his point. He says section 129, 1K of the Constitution is a complete book on its own.
Indeed.
And you cannot seek to import other sections of the Constitution into it.
Indeed. My lord, we do not seek to import other sections of the Constitution to it.
You intended to import section 168, 68,
268.
administrative justice issues.
That is with regard to the role of the speaker. However, as I am trying to do in these submissions, is to bring us back to what the applicant is actually seeking. And the applicant's assertion is that section 129K of the Constitution has not been properly invoked. And that means the role of the speaker does not come into play in this question. The first respondent simply has one case to answer. Where is your mandate for authority to speak on behalf of the political party? And where is your evidence that the applicants have ceased to be members of the sect? That is all that this application seeks to address. That is what it is about. And unfortunately, the first respondent submission completely missed that aspect. Even in the papers, there is no evidence of any authority. There is no evidence of any cessation of membership. That is the first part of section 129K. Before we start to speak of the validity or otherwise of the speaker's actions, we speak of the validity of the first respondent's letter. This is what the applicants seek to interdict. This is what the applicants are asserting is an act of fraud. Once that allegation has been made against the first respondent, the onus shifts on him to say, this is what based my actions. What is interesting, my lord, about the first respondent's submission is he's the first one to cry and say, call the political party to come and speak for itself. He said the political party must come and speak for itself. That is the exact concession that I'm speaking to my lord. He has accepted that he does not speak for the political party. He is on a frolic of his own to remedy issues of his own. But the position of the political party with regard to the applicant is common cause and undisputed in these proceedings. That the applicants were elected as members of parliament and of the Senate respectively under the ticket of the political party is not disputed. The letter from the president of said political party, who has been acknowledged in the submissions of both the first and second respondents, is not disputed either. My colleagues wish to hammer on the issues that have already been resolved by this court. It is accepted that the speaker has no role to adjudicate in the internal affairs of the political party. Those internal affairs are being brought before this honorable court. And the applicants, as the affected members of these purported reports, are saying we do not know the first respondent, and he has no authority to speak for us. Our membership has not ceased, and Section 129K of the Constitution has not, in fact, been invoked. That is the question before this court, and that is what the entire draft order speaks to, the validity of that particular letter. And as I have submitted, my lord, and I do not wish to overly admit the authority on this point, once that allegation has been made, the onus shifts on the first respondent to prove his mandate and to prove the so-called cessation of membership, which is really denied by the applicant. Once it is accepted that he cannot speak for the political party, once he has admitted that he is not the political party, and in fact has said, where is the political party? He accepts that it is not myself. The inquiry need not go any further than that point, as it is his letter that is being appealed. And to speak to the issue on jurisdiction, this is an application for a declarator and an interdict against the first respondent. The allegation is flawed. With respect, annexures ST1 and ST2 relied on by the first respondent are equally fraudulent, and in fact do not speak to any mandate relating to Section 129K of the Constitution. It is denied that he is a member of the political party, and it is denied that he is mandated to act for the political party in any way, shape, or form. ST1.
He did so in response to the annex that you had also filed. You filed in annex, I'm not sure whether it was PD1 or what, but it's one of your annex application, where you then attached a document that was authorizing some people to count aside the nominations of candidates in the election. That doesn't speak to 129K, does it?
Indeed, however, that document...
That's when the first respondent also filed a document countering that attachment that you had made. But you are right, both those documents are totally immaterial because they don't speak to 129K.
Indeed, my lord. However, the important acceptance by the first respondent is that those documents were authored by the leader of the political party concerned. And he accepts that he does not speak for the political party itself. I do agree with his lordship that those documents are not what speaks to the nub of this case. In those documents, it's sought to dispute the membership or otherwise of the first respondent, but it is admitted that even if the first respondent is a member of the party, and even if the first respondent was assigned to sign nomination papers for some members, he does not have the mandate to act for the party in terms of Section 129K. That is the mere case that is being made by the applicant. And there is nothing that the first respondent has furnished to this court to
back up. The only issue that I clarify is who does.
My lord, it is the appointed president of the political party who then wrote to the speaker.
So your point is that the Triple C party spoke in this application through the letter that was written by.
Indeed, my lord. Indeed, my lord. And the action emanates from the applicants themselves, because the applicants have no reason to sue the party. They're saying the party is not the one that expelled us. The party is not the one that has seized our membership in any way, shape, or form. They in fact have no relief against the party at all. They're saying that this is a stranger who has forged documents and is purporting to seize our membership. Which membership, at least at the point of them being elected, is an issue of common sense. And so this is why I submit respectfully, my lord, that once the first respondent claims that there's been a cessation of membership that nobody else knows about, it is up to him to prove his mandate to have seized such membership. And there is no such evidence that has been brought before the court. And accordingly, if we limit ourselves to the actual relief against the first respondent, this is a very simple case, which in fact has been admitted by the first respondent. It it's also admitted by the first respondent when he makes the call to say, let's bring the political party. What does he do? He distinguishes himself and his actions from it. And this is why I say, my Lord, that this case needs to go no further than that particular aspect, because we cannot have section 129K invoked when the political party has not said anything to change the state of membership of the applicant. My Lord, I think this addresses the preliminary points, but out of the abundance of caution, I just wish to address the second respondent submissions. I do understand where they were coming from in the need to defend the second respondent's position. And I wish to clarify that the office of the second respondent, it was never the intention of the applicant to disrespect the same. The paragraph refers to where there's an allegation of scandalizing the second respondent. I wish to clarify that this is fully directed at the first respondent. What this paragraph says is that the second respondent has turned a blind eye. And this relates to the submissions on the duty of the speaker, which I've accepted that do not actually extinguish the case that is before the court. And so for that,
in the drafting of the would you?
My Lord, it is I must state it is a team effort which involves a variety of...
But you reconcile that some of the language used today is completely unacceptable.
My Lord, I can agree to the extent that it was unnecessary for the purposes of these proceedings. And I think it stems from perhaps passionate but misplaced passion in this case, which is why I've not sought to justify what appears, but simply to clarify that if there is any indignance, it is really directed towards the first respondent. And perhaps the applicant felt, whether correctly or not, that a constitutional office such as a speaker ought to also have maybe given due consideration to the two letters that were before him. However, as I have accepted in my earlier submission, the issue of the letter having been written before the letter by the leader of the political party came, it affords the speaker the benefit of the doubt. And again, it is neither here nor there in determining the question of whether or not section 129K was properly involved.
Thank you, Councillor.
Indeed, my Lord. That perhaps I feel it is appropriate to extend apologies to my colleagues as well as the respondents and to the court. Should any of the language be intemperate for the purposes of the proceeding. However, it stems simply from a cry from the applicants that their own rights should not be so easily altered by the actions of one man.
Submitted that we are alleging that Parliament failed to fulfill the constitutional obligation. With respect, those are not our submissions. We have recourse to the relief that we are seeking. The case in very consequential relief arising from the case respondent so much so that even if you were not inclined to grant relief against the second to third respondent, we will be quite happy with you granting a order is against the third respondent. Once the action of the first respondent are declared unlawful, everything else falls away. But my second submission leads to your most important question. Who does this response? Who should? Who did? The second question, answer my next to the question is that the political party has advised the Speaker and the President of the cessation of members from the political party. But the point is made in our papers that it is not a political party. I need not to deliver that. But what is also clear in the paper that I have shown you, this has not been denied. Is that the actions of the political party themselves are not complete without the actions of the Speaker and the President of the Senate complete the matter that is before. It becomes important that is not been denied that before the Speaker and the President of the Senate, we two positions from the CCC, which were in direct conflict with each other. Is it to suggest that there is one CCC which detects the student opposed to the interim secretary general is another thing which advocate Nelson Chamisa is whose letters were before the Speaker of the Because on what basis did the Speaker or the President act on the letter by the President? They could only have done so if they were making a decision in respect to what the President told them, which may not, we submit, was incorrect for them to do so. And in doing so, they were not acting in terms of section 129, 1K of the Constitution, which distinguishes this matter from the Masumre cases and the other cases where announcement was being made in respect to how you deal with the letter written to you in terms of section 129, 1K. So that is the point that we need to understand. So the point we are not in that section 129, 1K was the misapplied.
You detract from the point that you had earlier on when responding to the person of the jurisdiction. She said she's not worried about what the presiding officers did. She's worried about what caused them to do what they did, which is the letter that the applicant said was brought them. But if you go back to the challenge, the actions of the presiding officers as having not been applied to section 129, you then fall squarely into the argument that Mr. O'Leary is making, that you are alleging that Parliament failed
but in respect to section 129, we are saying that that is not our argument. That is not the.
It's not your argument, you're making it.
No, my point, I want to be clear about that. That section was not, it is not as if the speaker and the president were acting because of section 129. Because they two conflicting positions before. I just wish to make that point that the court must take notice that there is those two positions. It should not be well, in regard to the issue that the first respondent was also appointed to sign for papers, I didn't answer. My name friend said that we did not answer to that. We actually filed a court application in which these colleagues were being challenged with respect to their actions. So that's my road is supposed to be. So the rest of the issues I want to do there,
You are done, Mr. Chairman.
My Lord, I will briefly make submissions on the policy in the evening. I will start off by saying that at the commencement, Humpty Dumpty was on the wall. Humpty Dumpty no longer. My Lord, the case stands or falls on the Founding Act. The Founding Act makes a case against the Speaker or the President, as the case may be. We have raised individualities and none of my letter friends, but they address the argument in our head of argument that there is no causa against the first respondent. There being no causa against the first respondent of the Founding Act, the withdrawal against the Speaker and the President is a withdrawal of the law force. My letter friends now agree with the argument I've put in our head of argument, that their codes should be something outside the present code. It must be a separate action against the first respondent in separate proceedings. Because in the present case, as we state on that point in English, they have not made a case, a causa against the first respondent, and they've admitted it. But they go backwards and forwards. In one breath, they say we don't make an allegation against the Speaker. We just want to first respond. This is our target. In the next breath, they say the Speaker was acting outside section 129, 1A. They can't get it both ways. Either they are for the Speaker did nothing wrong, and they are just going for first responding, or the Speaker did something wrong, and they are founding up that the Speaker did something wrong, and their departure from the founding up that is a departure from their case. Their case of their failure. Related to the counter issue, we made a claim to submission that they rely on inadmissible hearsay. None of them is related to that. Related by Chamisa, who is not before the court, ought to have been introduced to the act that that has not been done. They are inadmissible hearsay. The rule against hearsay also applies to documents. They have no concept of that. That is in our head of arguments. My Lord, in all the circumstances there, Humpty Dumpty cannot be rescued. No amount of preparing and piecing together. We pray that the application be struck off, alternatively be dismissed with cause. Those be our submissions on this level, which is the representative of this. Just one more point, my Lord, which has come to mind. My Lord did ask about the distinction between the Speaker and the Parliament. At page 11 of the Secretary of Judgment in terms of this officer's Parliament of Zimbabwe, that is the argument. Which is perhaps the reason why my dear friend, it's CCZ 2 of 20, Chamber of Municipal and Party, CCZ 2 of 20. Yes, sir. Tshabangu versus Parliament of the Republic of Zimbabwe, CCZ 2021. That's the judgment number.
2 of 21.
2 of 21. Which is why my learned friend then could go from that submission and say that we are not making any allegations against the Speaker in Parliament. We are making allegations against the First Responder. Which puts down the law. Thank you, my God.
We have no further submissions. Did somebody talk about the sitting of the nomination court? What is it? What's the date? The 7th. So it should be affected by the decision of the court in this. Thank you very much, everyone. The decision of the court is reserved, but it will certainly be out before the 7th.
All right, guys, this is quite very interesting. What was funny about these court proceedings is that I think that is Kanengon, hey, the attorney for the state, which is for the government of Zimbabwe, the parliament. He's the very same attorney that actually represented ZANU-PF. Remember when they were fighting in court with Citizen Coalition for Change and also Zeka, remember? It was ZANU-PF and Triple C, hey, if I'm not mistaken. The same Kanengon. It's quite funny because now it's a series of the same old people, the same script, same people, same attorney, same court, same whatever, and some whatever. And I'm just waiting to hear what will be the verdict of this whole court. The judgment really, yeah. I think we have time to waste, literally. Zimbabweans, we have time to waste. I mean, while other countries are building, they're sitting in boardings, they're closing deals, they're sorting out what's not working in the country. There's the rescue. It's a mess. It's just really a mess in Zimbabwe, honestly. Time to waste. I guess Sengezo is kind of getting the spotlight that he want. You got almost like 20 minutes airtime on Zimbabwe Broadcast Corporation. Again, we call it ZANU-PF Broadcast Corporation. So that's what people call it. He seems to be the man of the moment. And there's quite a number of allegations that he was bought a house. And there's also Hopo Oshimono, who is also robbed into the situation. Now you start to ask yourself, what the hell is going on in this country? It's like the country is built on deception. Since 1980, you heard that the person that was actually more popular was actually the father Zimbabwe, Joshua Kabukongomo, who did not get the chance to actually lead the country. And everyone is saying, we wish we could have had him as a leader. We saw how how Mugabe wiggled himself to the space through the fights with him at the Lancaster House in Tongogara. And then it has been a lot of conspiracy after conspiracy. It's abductions, it's killings, it's that, which I'm going to be touching the issue of abductions and torture and killings. I think in the next hour or two, I'll be back and I'll have a live on that issue. This is after a lot of people really have been abducted, but the recent one, which is Takuzwa, Takuzwa, right? Yes, that was abducted yesterday and also tortured. Absolutely unbelievable. So let's just wait for the judgment. That's what we're going to wait for. So guys, I just hope you guys have heard what some of the submissions were in the court. And then see you guys later on. I'm coming back and I'm going to have a live on the issue of abductions, torture, and killings in Zimbabwe. Also really bring down the story, bring in the story of SAS, SAS, a body or an organization that is really a terrorist organization that has been nothing but, a thorn in most of Zimbabweans' man's flesh. We want to look at that story, and as well as also, looking at some of the advices that people are saying. What can we do to move forward as a country? Now that we know we have this terrorist group in our country, we know it tortured. Is also President Emerson Mnangagwa was also tortured at the time that he went to exile in South Africa. We know Jonathan Moyo is in exile. We know Kasukure, quite a number of people. The Councillor of Citizen Coalition for Change, who was also abducted, tortured about a week or 2 weeks ago. You also now, I heard that he's in exile. While we're looking at all those ills that are surrounding us, the question we need to ask ourselves is, why are we then keeping this group that is a terrorist and that is a terror in our society, in our community? We'll look at that story a little bit later on our live. So thank you guys for tuning in. I'll see you guys later on. I love you all, and God bless Zimbabwe. Bye for now.